begin the process. Thank you.
Dear Heavenly Father, as we come here this morning to deliberate the nation's business, we ask that you will bless us. We ask that you will give us clarity. We ask that you will give us wisdom so that we will make the best possible decisions that will benefit the people of Jamaica. Continue to guide and protect those who are on their way. In your name I pray, amen.
Thank you very much for that prayer. All right, apologies for absence. I'm told Dr. or Member Guy, you have the list here. Mr. Edwards is on his way. He's 5 minutes away. Minister Malahoo Fort will be either late or absent. Dr. Marie Sky, unfortunately, can't make it today. And Senator Longmore will be late. So that's for the record. Any other? No? All right. Welcome and opening remarks. Marks, just to apologize for the late start. Welcome to all who are here. The members of the various entities, the ministry, Mr. Stein and his team from PAHO, the Solicitor General, who does not have a name tag at this point in time, and her team. Your unit is, ladies, on this, Miss Seeley Brown. Remind me again of your department, your unit.
OPC, Chair. OPC.
OBC.
Yes.
Okay. Thank you for being here. And then we are joined also by one other member. Thank you very much, MP Wilson. All right, so thank you very much. And we wanted to start a little earlier because we're going very slow. And I'm hoping we can pick up some grounds today, even though we have had the late start. So we'll go right into it by looking at the minutes, which are, or should be before you. Minutes of the last meeting, April 12, 2022. And I will ask that we look at the minutes now for any corrections and for approval. Page 1 of 11 pages. Page 2. Page 3. Page 4. Page 5. Six. 7. 8. 9. 10. And just the closing remarks for page 11. Any corrections at all? No? All right. Can I ask for someone to move for the minutes to be approved? Moved by Senator Cavan Gale.
Seconded.
Seconded by Senator Janice Allen. Okay, any matter arising from the minutes? There is a there is a summary page of the approved corrections or suggestions for changes that would have been distributed and perhaps would form any basis for a matter arising. But so just to reference that for your own education and possibly comment. It speaks to Clause 1 and the decision, 2, interpretation, Clause 3, objects of act, 4, powers of minister, and what was adjusted, 5, government undertaking comprehensive national education and information campaign, page Clause 6, 7, 8, and then where we are now, completing 9. So this single page would give you what we had agreed on. So if there are any concerns, you can raise it either now or later on. Otherwise, if there are no matters arising, yes.
Just for clarity, Chair, because these would have been principal agreement for actions to take place. And I assume that at some point in time we will see what those actions will represent.
Yes, of course. You mean the corrections?
The corrections.
Yes.
Right.
I mean, we will get a clean draft
Right.
to capture all the sentiments that have been, but for ease of reference, we've done this just for you to follow. Okay? All right, so that would take care of matters arising. Let's go now into the substantive matter. Mr. Edwards still isn't here, so we may need to lean on, do we wait on him or do we lean on others? I don't think Yanni can manage those legalistic interpretations and comments out of my office. What about others who are here? Do we wait on him a little longer? And then we see what, okay, if there is any clarity that's required, then we can go back to it when he comes. All right, so we were at, we had completed, I think, the Ministry of Education's comments, as I recall. And this is now Clause 9. And we then had agreed to move from there, same on the, still on Clause 9, but looking at the other comments. There's the Ashton Center for Health and Sciences, Health and Society, the Jamaica Psychiatric Association, and Boot to Go Pharmacy. And I think we had, and the Jamaica Chamber of Commerce. So let's do them in order then. So the Ashton Center for Health and Society looked at Clause 5.3 of the WHO FCTC, best practice level in the bill, should ideally, members of the Parliament are not included in the Tobacco Control Bill's provision, which aim to manage conflicts of interest in public administration. Provisions of Clause 9.3b and Clause 10.1 do not cover MPs because of how public bodies are defined in the bill. Any comment on that?
Are they saying that they should be?
Right. It says that members of Parliament are not included in the Tobacco Control Bill's provisions which aim to manage conflicts of interest. I suspect it's suggesting that it should be specific, or should I say explicit, around issues of conflict of interest involving members of Parliament. The question is whether Clause 9.3b and Clause 10.1 incorporates in public bodies elected members of elected public servants, members of Parliament. Any of the legal minds wants to weigh in on that? I thought it did, but anyone? Yes, Mr. Stein, go ahead. Sorry.
Thank you, Minister. I think that from the position that we've seen pretty consistently in the range of countries is that it should apply to the range of members of Parliament as well. That's the intent, to ensure that it is a comprehensive approach to these. Thank you.
Right. The question, and I accept that. The question is whether or not it is incorporated under what is stated here. What this is suggesting is that it may not. My assumption was that it did. What is the is
Chair, as the bill reads now, it doesn't, because they're not.
Can you remove the mask for me? I'm sure
I'd
you're.
rather not. I'll try to speak a little clearer.
Okay.
As it stands now, Chair, it doesn't include ministers. I don't know if that was the policy when the bill was drafted, but certainly members of Parliament are not employed with public bodies. So if the policy is to change it, well, then that can be considered.
All right, well, let's make a note of that and have Mr. Edwards weigh in on it when he gets here. So basically, we're saying that the benchmark practice would be to include elected officials, and this particular area would not sufficiently cover them. All right, so I'll note that, and then we can get a perspective. Where am I? Yeah, go ahead, MP.
So being that I'm the only MP here, I would just, and you, yeah. All right, but I was just saying to Mr. Stein as well, while we would want to incorporate and encapsulate the entire act as it's portrayed, we'd want to know the value of including the MPs. So if you could elaborate a bit more on, I know you said it's generally conceived and perceived and included, but if there is any specific value that this would bring, then could just kind of highlight it in terms of from the MP standpoint.
If there's any value, sorry, what?
Yes, in terms of including it.
Members of Parliament?
Yes.
What the value is? I mean, it's... Anyway, you go ahead. Your question was directed at you.
Thank you. I think it's important to note that actually we understand that it was actually originally included in the original wording of this. And so there has been some, I understand that based on some input, it may have been removed. I would strongly encourage the committee to consider reinstating this. And I think that this is the intent, as I think I mentioned, is it's intended to have a comprehensive approach so that all parties would be subject to the same considerations in this respect. Yeah. Thank you.
I'm inclined to support that, I must say. I think that as policymakers, legislators, we would wield significant influence over decisions around, guidance and what is allowed and what is not. So it is in keeping too with the principle of declaration of interest or potential conflict of interest that MPs would need to do anyway in their normal course of activity. So it would be an oversight if to my mind, it would be an anomaly, I should say, not for it to be explicitly captured. Mr. Edwards, we appreciate your presence and we understand your challenges. But we're looking at clause 9 and the observation by Ashton Center for Health and Society, speaking to MPs not being included in clause 9.3b and 10.1 around which speaks to public bodies and conflict of interest. And the discussion here is that elected officials should also be cited as not, for recognizing where conflict of interest could exist, which I think is in keeping with the general rules around what we do now. Is there anywhere in the otherwise from here where that is addressed or no?
Morning again, Minister and members and colleagues, and my apologies for late arrival. Anywhere else in the bill, Chair?
The suggestion is that we should include elected officials as part of that.
Chair, that is the thinking coming from wider guidance in terms of the public health community, in terms of the guidelines on the implementation of the FCTC, that scope is consistent with those guidelines to include the broader range of public officials and not just the public servants. Yes, so that is consistent with the guidelines.
Not addressed here.
It's not here. Here it is more limited.
Okay, so I'm going to allow you, not now, at an appropriate time, to reword that, to incorporate that. Is that okay? Is that okay with everyone? Yes, Senator Cullen?
I just wanted a little clarity. Whilst I'm accepting what you're proposing with Mr. Edwards, this is the clause we're saying that nobody in the public service then shall be entitled or allowed to invest in the tobacco industry. This is what we're contemplating right here. And to add to that, members of parliament. And if I could also bring your attention, if that is the case, then if we look at 9.2, a person employed with a public body shall not solicit to accept contributions of any kind from the tobacco industry, then it would stand to reason then that, if we're looking at support in one way, we'd have to look at it in another, and therefore not accept contributions. I mean, fundamentally, I still have my own reservations with the proposal that persons in the public sector shall not invest in the tobacco industry. If I have my portfolio that includes on the stock market and have that opportunity, my personal view is that I should be entitled to invest. It's not impacting my daily work. So, but obviously this is for contemplation for all.
The thinking, Chairman, and following on from that contribution is that there is such a fundamental conflict and potential for compromise if one has an interest in the industry that has its own agenda, which may conflict with the public policy in relation to restrictions or control on tobacco use. So that is really the thinking behind those controls or restrictions. It's not a general restriction on freedom of, investment or contract, but it is seen as such a likely challenge for persons who have a investment interest in an industry that is being controlled. That is a challenge.
So, Chair, 9.1 speaks to a person employed with a public body. Now, that's very wide. That can be from the CEO, the executive director, the managing director, right down to the messenger or janitor employed to that public body. And so, in scope, what it is demanding is that they ought not to relate themselves to any activity in what, from 9A right down to 9.2, 3A, B, and C is saying. I'll give you an example. Molan, if you are employed to a public body and you want to invest and you go to one of those investment brokers and say, I am putting up some retroactive payment that I would receive as a public sector employee, and I want that to be invested. That broker is going to make a determination as to where to apply such funds. It may happen that such funds be applied to that entity which is listed on the stock market, unknown to Moreland Wilson. But then 9.2b would be, he would be liable to the actions taken into where he would have invested in the tobacco industry or any related ventures. See now, again, that janitor or that messenger or that clerical person in the public body, employed to the public body, would have a little wholesale supporting and supplementing the salary. You know, public sector employees now are complaining about salary, Chair. I just had to put that in there, but you know, that's me. But again, what this is driving at is that if they have that little shop that sell any brand of cigarette, they would be exposed to liability. From your start where a person employed with the public body, it involves every employee from top to bottom. Do we really want to expose public sector employees to what is contained in 4? Because the contravention of any of the provisions of the section commits an offense and shall on summary conviction before a judge of a parish court be liable to a fine of not exceeding $1 million. That might be half of some of them pay. 6 months. Right? Now, do we really want to expose our public sector employees to that? Or do we want to define it in a certain way where it is more targeted rather than suggesting that all employees attached to a public body must be exposed to this? That's my concern with this. Really, let's define what the motive that we are trying to fix with this, and let's be more targeted in nature rather than have this broadband, all-inclusive type of clause, Chair.
Sure.
Yes, Mr. Tucker and Ms. Curlew, what is the convention, or maybe I should ask Paho actually, what the convention is in terms of what we have signed on to as a country in the interest of eliminating tobacco consumption?
If I may, consistently it is broadly applied. And I think the reason why it is broadly applied is it is, again, easier to apply broadly than trying to target these things in a narrow approach. Because if you try to target them in a narrow approach, it becomes subject to interpretation. So if you are intended as an example to say senior managers or senior advisors, then it becomes a question of who is a senior advisor, who is a senior manager. And so it's intended to be comprehensive in the breadth of the public service. And I would say when I say the public service, it's not only, as I say, a person that is employed by the public body, but also including the representatives in government as well. Thank you.
Anything to that NCDA? Go ahead, Ms. Curlew.
Sure.
Morning, everyone. I'm looking at the needs assessment that was done by WHO for Jamaica.
Yes.
And where Article 5.3 is concern is that Jamaica has not yet met its obligation. And certainly we're trying to protect the industry from interference from vested interest, which may be us in the industry, in the public sector. So we want to protect it totally from interference, and I think it's something that we should adopt and make sure we implement. Yes.
Yes, Ms. Dennis.
Thank you, Chairman, and good morning to everyone. So to pick up from NCDA and what was just mentioned by Mr. Stein, we are also mindful that not only does the convention outline Article 5.3, but there's another tool or instrument that we are given to help us to interpret the convention, and that is the guidelines for the implementation. Now, I know that oftentimes it is mentioned that it's just a guide, but I want to reinforce the fact that the guideline these guidelines have been adopted by the parties to the convention as instructive in terms of what they are putting in place. And a section of the guideline which speaks to Article 5.3, in fact, it speaks to it in relation to avoiding conflicts of interest for government officials and employees. So I've listened to the reasoning, and I believe that the concerns are quite reasonable. But in looking at some of the spirit of the guideline in terms of non-interference and transparency, it does speak to the avoiding of that conflict of interest, not only with respect to putting the burden on officials, but also on employees. And it mentions that that there must be clear rules regarding conflict of interest for government officials and employees working, not just those working in tobacco control, as a means of protecting the policies from interference by the tobacco industry. So we might want to consider that.
Right. So I get that. And I suspect the concern here is, I think there has to be general consensus around avoiding conflict of interest. I don't think there's an issue there. I think the issue now becomes the measures that are imposed and whether or not those measures become almost draconian, even though I think generally we want to discourage participation by public officials as a signal that tobacco is a deleterious, harmful product in all ways. and I think that's the issue. We don't want to send a signal that is going to water down the concerns that we have as legislators around tobacco consumption. And that would be the concern that I have. But I see where Member Gale wants to come in again.
So, Chair, there are guidelines that promotes and encourages changes in behavior and allows for individuals to understand their scope of permissiveness. And I believe this is what this is seeking to do. But when you twin it with the liability to criminal actions, that's where I'm having the difficulty.
Right, and that's the point I was making. I think we have to be very explicit around the avoidance of conflict of interest and in any way, shape, or form suggesting that it is okay to either consume or deal with or in the consumption of, facilitating the consumption of the product. The issue is whether or not we should be charging $1 million for a person who inadvertently may, I don't know, invest in a pool of funds that include a pool. All right. So, Mr. Edwards, how do we solve that injury if that is the intention?
Okay. Well, Chair, towards a solution, so to speak, there are different approaches within the Commonwealth to deal with sanctions for public servants in this matter of conflict of interest in terms of their personal activities and investments. And the criminal sanction is not always the most appropriate tool or necessary tool. There's also disciplinary. Some countries, what they do is they have something in their code or their regulations for public officers that have, guide rules in relation to investment activities. So that's a possibility that could be looked at.
Senator Allen.
Thanks for that clarification or additional information, Mr. Edwards. I want to go back to add to that. The Mrs. Wright made mention of the guidelines that we have signed on to, and my understanding of guidelines is that they're as such guidelines, but my interpretation, what I understood from what you're saying is that we are almost bound to what these guidelines are saying, and I thought it would be more guide us based on our realities and what we are faced with. And so I just needed a little bit of clarity on the matter of the guidelines and what we've agreed to do, so we're very clear.
Okay, and I'm happy to provide that clarification. So the guidelines are consensus documents which were adopted by the Conference of the Parties, and by adopting this, the parties have essentially signaled an intent to be bound by the provision. So it's not an additional instrument that we signed, But when these were put in place and when these were being drafted, parties would have consented to the words of the guidelines in terms of how they want to guide new parties or guide themselves in terms of putting in place particular provisions of legislation. And not just that they have contributed to the text of these guidelines, but they would have also adopted it, signaling their intent to be bound by it. So that's the extent to which I was making the intervention.
Right. So I think, but I don't think that the two positions are at odds with each other. I think we're very clear, all of us, about the conflict of interest issue, which is captured there. I think the issue really is a penalty. So what I was asking Mr. Edwards to look at, which you had recommended an approach, is to be very clear, very explicit around the conflicts of interest and the avoidance of it, and then determine how we weigh the penalties to suit the crime, if you will, recognizing the context of our situation. So you had made a suggestion, and I'm just wondering whether we should allow you some time to see how you can capture that.
Yeah, well, our team, yes, we would need some time, because there are some other considerations, Chair, such as whether one would want to distinguish the sanction according to the role of the officer. In other words, an officer who is directly involved in public health control.
Yeah, exactly.
As opposed to
something like that.
An officer, in a totally, apparently unrelated area.
I think we have to look at it, because I suspect it's going to be one of the key points of differences when it comes for the debate in the Parliament and elsewhere. So I would give you some time to look at that.
Thank you.
Understanding what we're trying to achieve, very clear signal, not compromising on that, and then further looking at some deviation or variation, if you will, around the punitive measures where breach has taken place. Okay?
Oh, okay.
All right, I see Senator Longmore, and then I'm going to see Miss Wilson, right? And then I'm hoping we can move on from here, because we're really going slowly, guys. Go ahead.
And my apologies for being late. The 9 o'clock is a little bit of a stretch for me, realistically. I recognize that we're dealing with Clause 9, and I just wanted to, and I think Mr. Edwards chimed in with the point that I was going to make, with the JPA's concern regarding the level of staff involved. And for us, apart from the penalties, as mentioned by Mr. Edwards, our consideration was more so on the other end of the scale, where lower level employment persons would be kind of denied of the opportunity when they're not directly involved with the industry itself. And so someone like a janitor or ancillary staff member who is trying to enhance his income would be restricted. So just to add that I endorse that approach in terms of...
Well, my approach is to restrict all employees. So let's be very clear. I am not going to give any indication that because you're an auxiliary staff,
okay,
you should not abide by the conflict of interest, especially if you're working in the space,
yes,
the health
definitely.
space. But I do appreciate that to charge $1 million in this context may actually be beyond punitive. It could be actually cruel and unusual punishment, if you will, for want of a better term. So I would want us to look at that, but I want to make it clear that the signal must be very, very strong in terms of what is sent around conflict of interest. Can we move? Oh, you had a concern, Ms. Wilson.
Yes, Chair. Just to point out that if inclusion of elected officials is being seriously contemplated, a different form of penalty would also have to be contemplated. So
exactly.
Just to make sure that that's left
right.
in the picture.
And that again is in keeping with the principle of those who make the rules should not be seen as the breakers of the rules, sort of thing. All right? Or evade them. Yeah.
Mr. Chairman, if I could ask, through you, of course,
Sure.
Are we looking at public sector from in every area of the public service, or are we going to be more inclined to look at the areas that are related to the oversight of tobacco? This is not what this is everybody, including including the Water Commission people.
I know you have to bring that in, Road. So. All right. So, Mr. Edwards, you want to respond to that, and then, well, I think Member Gale has responded to it. Right.
Yes, the intent is to cover every person who is in public service.
Yeah. And I don't have a fundamental difficulty with that. I do believe that when it comes to how you apply penalties, you can distinguish those who are at a place that can more effectively influence or the industry, and therefore would have more to gain and so more to lose if they engage in that process. But I think we should send a signal throughout the public service that this is not a desirable product and not a desirable. I mean, it's not much different from saying we must reduce sugary drink in schools and in the health system. I mean, that's policy that we are trying to implement.
I have to consider even a security guard or someone who he's fortunate to probably have an employment and now would want to try and multiply. I mean, he has nothing to do with the subsequent behavior change. I can fully appreciate our level and the level of, so I think the balance, and this is coming from me who has that great concern, but I also have the concern of denying possible upliftment for persons who may seek to do it in that way.
The challenge I have with that position, member, and I'm not claiming chairman's privilege here, I'm just giving my view as we all are on an equal basis. The challenge I have with that view is almost, it conveys a message that because you are somehow deprived or not as fortunate, you are allowed to engage in a process that in and of itself is destructive, not just for you, but for others who you are influencing, whether through distribution channels or otherwise. And I'm saying we have to decide whether or not we're going to send a strong signal around tobacco consumption. The evidence is very clear that it is one of those products that not even in terms of moderation it serves any good purpose, unlike all the other food ingredients that we know about. And the obligations that we have made is to, as best as possible, reduce and eliminate its consumption. And I really don't want to water that down, that messaging down, because someone is a security guard, as opposed to them being a psychiatrist or a manager. I think the message should be consistent across the board. Now, I do agree that the security guard, just to use your terminology, may not be as influential in promoting the product as maybe a manager or someone who works in policy in public health. And therefore, those should be held to a higher standard of accountability. But the message around it affecting all, the consumer and those who promote its consumption, should be discouraged from doing so. I think it's a message we should maintain, we should hold on.
You see, Chair, just my final point on this, and I'm going to somewhere that Mr. Edwards had gone in terms of policy guidelines within organization. And I know that a number of these public bodies may have conflict of interest policies that would treat with this particular situation. And I would more support where it's a policy guideline that encourages a type of change in behavior that prohibits the conflict of interest, rather than you have, and that can create corrective actions being taken against any of these individuals. But where it is exposing or tying the criminal action, you know, that's a different focus.
And that's my point.
Yeah.
And that's my point. That's my point. I think we should send the signal very clearly, but we shouldn't be overly punitive in terms of criminalizing breaches at certain levels. And that's what Mr. Edwards need to construct or reconstruct. Yes, Senator.
Mr. Chair, while we're not at odds about, you know, the intent of bringing across the issue of tobacco addiction and tobacco issue as very serious, I just don't think that as it's written, and I agree with the concern of Member Gale, I don't think that as it's written, it really achieves the aim. And if we're to look at even an administrator in a ministry that's completely unrelated to the tobacco industry, I find that it's a little bit restrictive to just broad brush all public officials. And I know that that's not your stance, but I would love us as a committee to consider the very real implications of this. You know, when we're looking at legislation, that's the first thing I learned, that we have to be practical. And when I look at it, how practical would it be for us to actually achieve this and monitor this? So that's my concern. And I would put it to Mr. Edwards, just for us to look at how something like this is actually reenacted in probably other Caribbean context, so we can put forward something that's actually practical and achievable, because as it is, I think that would be a very hard feat to accomplish.
Okay, before Mr. Edward comes in, I mean, I wouldn't say that it's not practical and achievable. We do have policy about no smoking in public spaces. Yes, some people breach the rules. Yes, it's difficult to enforce, but it applies to everybody. And you know, for the most part, people comply, and there's always going to be deviant behavior. So the idea that someone has to engage in selling cigarettes in an inner city community because he has to do a hustle, if you will, to supplement his income. There are many other things to sell. So it's not like without cigarettes you have nothing else to sell. I'm just giving an example. I mean, I understand the controversy around it, but I really do believe that we need to separate the issues around the penalties versus the messaging that we're trying to send. I think if we separate them, we probably would appreciate more the importance of sending the signal. Mr. Edwards, you want to come in here?
Well, the truth is, I mean, there are different approaches even within the Caribbean and the Commonwealth and internationally. So some countries have the broad approach dealing with public officials, public officers, which is what we are looking at here. Others will speak more to public officers who contribute to the formulation of policy in relation to public health, or who may have some connection in that regard. So there are different approaches throughout well, not just the Commonwealth, the world, the parties to the treaty, to the convention. So it is a question of,
all right, so
if I may, Chair, if I may briefly, just look at how the FCTC guidelines are framed in terms of the specific recommendations, if I may just briefly do that. So, for instance, recommendations state that parties should mandate a policy on the disclosure and management of conflicts of interest that apply to all persons involved in setting and implementing public health policies with respect to tobacco control, including government officials, employees, consultants, and contractors. Next, parties should formulate, adopt, and implement a code of conduct for public officials. So this is everybody, prescribing the standards with which they should comply in their dealings with the tobacco industry. Next, parties should develop clear policies that require public office holders who have or have had a role in setting and implementing public health policies with respect to tobacco control to inform their institutions about any intention to engage in any occupational activity with the tobacco industry, whether gainful or not. Next, parties should develop clear policies that require applicants for public office positions which have a role in settling and implementing public health policies with respect to tobacco control to declare any current or previous occupational activity with any tobacco industry, whether gainful or not. And next, parties should require government officials to declare and divest themselves of direct interest in the tobacco industry. And then parties should not allow any person employed by the, that's different. That's looking at it from the other perspective. So there are a number of different approaches, but the focus really is primarily on persons who are likely to have a role in the settling of public health policies in relation to tobacco control. That's at the minimum. That's the minimum standard. The highest standard is really, as Minister Chairman is saying, that there has to be a signal in relation to public officers, because public officers are seen as representing the government, as representing the public policy. And that is why the convention seeks to put a separation between the public officer, regardless of where that officer is stationed, and the tobacco industry. Now, in terms of how you treat with the actions of a public officer, it may depend on their actual role or their actual level of influence and so on. But there has to be a general signal in relation to the public officer.
This is the point I'm trying to make, if I may, is we deal with persons who are directly involved or potentially directly involved in a way that applies stronger punitive measures. And for the rest of the space, we send a signal to discourage the kind of participation in the process. And that's if we can achieve that, I think we wouldn't be at the extreme that you speak of, but we'd be more than the minimum standard. And I think in the context of Jamaica, you asked a question about binding agreements and some of these things. I think we have to also shape our laws to fit our circumstances. And we do have an issue, as I've said, with the NCD epidemic, if you will. And tobacco consumption is a big part of the problem, and particularly among socioeconomic groups that can least afford health care when they are so affected. So I think the message has to be strong enough while not being draconian, and that's the position that I would take. Huh?
One last clarification of Mr. Edwards, if you don't mind. You mentioned in the guidelines public officials who are required to make declaration, and I get that. Let me ask, could you please define for me who is a public official as opposed to a public officer who works in the public sector?
Yes, the way the guidelines are framed, they have a distinction between, and I'm glad you brought that up, that there's a distinction between the government official, who would be the person who would be probably directing policy, as opposed to the employee, and so this is where there is room for flexibility.
Guidelines, it says public officials must declare, and I get that and accept that, but the public officer who is the employee, it was restricted or limited to those involved in the administration of health.
Public health policy.
Public health policy. So it's not all of public sector. It's public officers within the health and then public officials across the board. Did I interpret that correctly?
Yes, but what I would say is that it's not that there is no, there's no duty on public officers, regardless of whether they're at the official level or at the general employee level. Yes.
All right, guys, members, we're going to have to move on from this because we've spent 45 minutes on one submission. Mr. Half a clause. It is big, but yeah, and I agree, but I think we agreed that we would adjust the penalties to suit the influencers and at the same time send a message right across the board to discourage participation in this kind of activity. And I think that's a fair position, frankly speaking.
Minister, just seeking clarity. When you say the influencers, I think it's tied into what Senator Allen was asking. Is it the direct, so can the Minister of Tourism?
No, well, the influencers, as outlined by Mr. Edwards earlier, would be ministers of government. It would be, health personnel,
yes,
all public health personnel, those associated with policy directly related to the trade, importation, all of that, so oversight of the industry, that kind of thing. I think we can figure the language out there, and then a signal to the public sector generally around discouraging participation.
And in crafting, Chair, I just want us to bring attention to what careers had to say about it in terms of fundamental human rights and opportunities to invest, just to keep that in the back of our minds.
Human rights for what? Choice?
Yes. Yeah. So it's just to say in terms of the possibility of influence, if your person is in that position.
Right,
yeah.
Okay.
Mr. Edwards, would it mean that you'd have to insert some new definitions in Clause 2?
You may have to, yes.
If we have to, we would.
Okay. But I think it requires some amount of study, so I would allow Mr. Edwards to go back to the drawing board with his team, and then we can, at the next sitting, maybe not the next, because the next sitting is tomorrow. So you may not have time for that, but certainly shortly thereafter, give us a wording. Can we move on now to the Psychiatric Association and their query, Clause 9.1, being questioned if there should have been employment for this provision. What if we're someone working? I think this kind of addresses the same thing. Yeah, so I think that will address that. Boot to go. Ban on investment, rationale for inclusion of certain restrictions in the bill is understood, but the proposed ban on investment in tobacco by persons associated with government is absurd, and so on and so forth. I think, too, that this clause will address it by speaking to the key influencers and discouraging everybody else. So I think that would take care of Clause 9. I think the Jamaica Chamber of Commerce. Regards to Clause 9.3, B and C, prohibition on investment in industry, unconstitutional, okay, same line. Charter of Rights stipulates that in order for something to be done, it must be justified in a free and democratic society. I say with due respect to this position that with rights have to come some responsibility. And ultimately, the burden of cost around taking care of the deleterious effect of tobacco consumption lies with all of us, not just the individual who makes that choice. And so in a sense, the responsibility becomes all of us, the collective. And the cost associated becomes a part of the collective. So I don't accept this argument. I think it is one-sided, and it has to be balanced with the responsibilities also, and that has to be defined in the broadest sense. Certainly in the public health space, where taxpayers foot the bill for public health. So that would be my position on that. Can we move on to 10? Sorry to appear to be pushing, but at this rate, I want to finish this on table before the Christmas season. All right, 10. So I'll start with part 1. I think the corporate accountability. Is that correct, Madam? Corporate accountability, right? Yes, sir. All right, so Clause 10 deals with assignment of duties for public body and making of disclosure. Corporate accountability it is being recommended to insert the following language to clause 10.2. Pursuant to subsection 1, Ministry may establish guidelines to provide because the engagement in occupational activity may create a conflict of interest, and it goes on around prior to designating their representatives to the meetings of the Conference of Parties of the Convention or any other protocol, its subsidiary bodies, or any other bodies established pursuant to decision of the COP and its governing body. There's a lot of legalistic terminology here, Mr. Edwards. I don't know if you want to help us with the interpretation of that, or if yes, go ahead.
I would like to ask Mr. Edwards, clause 10.3, a person who seeks employment with a public body shall be required to make such disclosure in relation to any current or prior occupational activity or any other affiliation with the tobacco industry, or such other activity as may be prescribed. What I would want to ask is how administratively can this be done? With all the public bodies, with all the employees, with every recruitment activity that is taking place. How do we possibly see this happening? I'm seeing it as a possible administrative nightmare.
Well,
what was the thought behind this?
Well, the first comment I'd make in response to Senator Gale is that this is not new. From two perspectives. In the public service, I had to do it. I had to disclose every board, every organization I was affiliated with. In terms of how it was administratively handled, I assume it was dealt with appropriately in the appropriate place. But I had to make that disclosure as a public officer. And secondly, this provision directly relates back to the guidelines we just spoke of in terms of the avoidance of conflict from applicants. So from the get-go, what you're seeking is to ensure some kind of integrity before persons become engaged in the public service. So it's not new from those two perspectives.
Chairman,
Yes, go ahead.
if I may suggest that, again, if we were to look at it as a level of employment, so beyond a certain level of employment, this disclosure is required. I think it also would tie in with the approach that we're seeking to do for the previous clause.
What is there, Mr. Edwards, what's the sort of benchmark that we would use for this to ensure that persons are not, quote unquote, innocently placed in a sort of a situation where they may have some indirect connection but not? In other words, would the principle of the segmented application of a punitive measure apply to this also, similar to what you're rewording in the previous section, section 9?
I think it would have to, Chair, it should. To be consistent, it should.
Okay, so can you re-look at that again, not to eliminate the need to be very specific around the need for disclosure,
yes.
And I do believe that disclosure is important,
yes.
but how that disclosure is...
Except, Chair, remember, we're not dealing with a criminal penalty in this case.
Well,
in this case, subsection 4 is speaking to appropriate disciplinary action. So it leaves it for administrative
So it allows
procedure.
for discretion.
Yes, yes.
What say you, members? I mean, that is a material difference between 9 and 10.
Well, 4 speaks to that, 4 speaks to the person that may refer the matter to the relevant disciplinary body for appropriate action. And I'm assuming there that they would have their different disciplinary guidelines that would treat with that.
Indeed.
So based on what you had explained earlier in relation to my questions, and I'm now reading it in tandem with
So we can
4.
leave it. We can leave it then.
Yeah.
Excellent. I'm assuming we're all agreed. Can we move on to item 11? Is there 11 here?
Excuse me, Chair.
Yes.
Just back to 10.4. So the matter would be referred to a relevant disciplinary body for appropriate action, but this is a new, I'm not sure that every disciplinary body would have, that this could fall under a disciplinary action then, or a disciplinary offense. So I'm looking at, for instance, the public service regulations. I'm not sure this would fall into any other categories, unless there is some mandate to tell the different bodies, because when you talk about a public body, different public bodies have their own rules. All of them don't use the public service regulations, and they make their rules, and what they do is they will have, I know for instance, at least 2, they have their rules, and they tell you if you breach specific rules, these are the sanctions that are liable to be imposed, but they have to set them out. So I'm just wondering now if you may have a gap that you could refer it to them and they say, well, this is not something we sanction, or we can have a disciplinary proceeding for.
So you're saying what is the appropriate body?
It's more than what is the appropriate body. It could be that you know that there is you will have an appropriate body, but there may be no sanction, because maybe this is not something that you can sanction for. Because this is a Tobacco Control Act, but I have an entity. We make up our own rules to govern our own employees, and our rules may not address this. So I'm just wondering if maybe the approach should be to tell the different bodies that they should include this in their rules.
But, I welcome Solicitor General's intervention, because this goes to the fact that not everything has to be prescribed in law, and this would be therefore sending the signal that administratively the public service and those engaged in administering public bodies may need to ensure that they have consistency in terms of their own rules of engagement with staff as to what is expected. So I do appreciate the intervention of Solicitor General, but this is really sending a signal for the public service to seek consistency in approach. So who doesn't have the appropriate provision, then hopefully they will be able to formulate such provisions. Thank you, Chair.
What it is seeking to do, therefore, Mr. Edwards, you spoke about the respective code of ethics or code of practice. Based on what Solgen is saying, then before we start getting to disciplinary measures or disciplinary procedures or disciplinary guidelines, we have to establish what the code of practice ought to be. The rules have to come before the disciplinary measures. And so what it is suggesting is that as it relates to this particular legislation, we have to establish what those code of ethics or code of practice are going to be, and then define the procedures that are going to be applicable to them as it relates to the public sector.
So what's the decision, or what is it that is being recommended?
So, Chair, you would have had 2 options. One, just as how you're sending a signal here, you could have sent another signal to indicate that whatever code of ethics that you may develop here, that these should be considered to be incorporated by rules of public bodies, or you use moral suasion and a public education campaign. So you don't put it in here, but your ministry will now try to actively engage different public entities to have them incorporate rules.
The logistics of that could be a nightmare, I think, and that's the real challenge that I have. I'd prefer to send the signal in the legislation so that it is a matter of record and the intent is a lot more firm, and then you build around that. But for you to go into every entity trying to get them to develop a policy, I mean, well after you and I are retired, we would not have covered. After I am retired, sorry, you're a young lady, we would not have covered a quarter of those entities. So I would want to find a way to make sure that it's
just like how every public body now operates under the guidelines of the PBMA, right? And they always, before they act, they always make reference to their actions that are going to be carried out. So if we lay the foundation with this legislation, then they would have to act accordingly. But what it would mean is that you would have to somehow, through your ministry chair, make such advisory or give such instructions.
You know,
go ahead, Edwards.
By putting this provision in, even if we don't do anything further, what you have done, what the Parliament is seeking to do, is to create some duty, statutory duty on the employee not to engage in activities that create a conflict of interest. So if in fact you have, run in contravention of subsection 1, for example, or 3, you have breached a statutory duty. So I would like to think that many codes or rules that guide the behavior of employees may speak to something about breaching provisions of law or breaching statutory duties, because that's what you would have done. So even if there is no specific provision in the code speaking of action for, specifically this matter, they would have contravened a provision of this statute which obliges them not to engage in activity which creates a conflict of interest. And I think it will be difficult for an organization that has an employee clearly running afoul of a statutory duty not to have some kind of measure that they could take in those circumstances.
I just want to be sure, though, Chair, through you, that the emphasis in authority in the first instance must be placed on the person in charge to determine the scope of permissiveness, and then it cascades down to the employee. In other words, the employee must become aware of how they must act in relation to the promotion from those in charge, and that it don't come from the employer up, it comes from the employer down.
Yeah, well, Chair, yes, and I think what Senator Gill says ties in with what Sullivan said earlier. The one approach is to deal with the public sensitization and information sharing in this regard. Thanks.
Okay, can we then accept that and move on, Mr. Edwards? All right. Moving. Mr. Edwards, just repeat the decision for us for the record.
I understood that the committee is not recommending a change in the text of 10, that's what I understand, but that the committee would be amenable to, looking at ensuring that there is appropriate public education and sensitization in relation to this matter of conflict of interest. But the committee, as I understand it, is not recommending a change in the text of this clause.
But Chairman, if we are not recommending a change in the text, there would be a conflict with Clause 9 if we were to change Clause 9. Because what we're contemplating with Clause 9...
Not really, because remember Clause 9 has...
Clause 9 is a criminal sanction.
Measures, which we had said earlier, so it wouldn't necessarily...
It would not...
No.
Because this says any employee engaged to a public body.
Right, but remember now, it is going to make a distinction around punitive measures, criminal liability, as opposed to those that it would not. So it's a substantially different...
So we're not considering the level of employment again?
No.
Well, in a sense, though, Chair, we are. But the way this is worded, it covers it. Because it's saying a person employed shall not engage in any occupational activity which may create a conflict of interest. So it points directly to... So it would have to be an activity that would be in conflict.
Fantastic. Okay, great.
All right. We're going to move to Clause 10. Are there any comments? No? Okay. 12.
Chair?
12. Right. None on 11. So let's move to 12. And in part 1. Okay. All right. So there are comments from the World Health Organization. The regulatory options included in the conference of the parties decision suggests that consideration be given to adding electronic non-nicotine delivery systems. I think we have done that, haven't we? Mr. Edwards?
Yes, we have, Chair, insofar as we're covering...
But they're referring to 12.1, yes.
Yeah. Well, Chair, insofar as this is speaking of the non-nicotine, then we would, we would have to refine it, because so far it's covering the nicotine products only.
Right. So could we make a note of that?
Yes.
I think that's important. Heart Foundation recommending subclause 2 must be strictly enforced. In accordance with the provision of the bill, there should not be any enclosed smoking lounges, tobacco products. So that would address e-cigarettes, the second part. The other one about in enclosed smoking lounges. What is I mean, I've seen these smoking lounges in other countries. I've seen it in the airports, for example, where people go in and smoke themselves partially to death in these smoke-filled cabins with an appropriate set of standards allowing for, whatever, extraction of the smoke and so on, which separates the smoker from the non-smoker. This is where I think the freedom of choice may be something worth appreciating. I mean, if somebody wants to go, it's still a big cost to everybody, but I mean, what is the sort of general, what entails now in other jurisdictions around these enclosed smoking lounges? Recognizing that there'd be no chance of secondhand smoke or exposure. Is that NCDA, you want to comment here? Is there...
We have after third-hand smoke is something that we're concerned about as well.
I didn't get that, sorry.
Third-hand smoke, so that's when it's in the clothing that the person may wear, their hair, furniture as well, curtains, but they would be outside. So if they smoke in the lounge and come on let's say the airplane, and you're seated beside one another, and that person has sinus issues or asthma issues.
But what is an enclosed smoking lounge? Is it a roofless area, or that's not enclosed? How would you interpret that? Yes, Mr. Stein.
So I think I'm familiar with the type of establishment that you were referring to as a smoking lounge. And I think that typically is an enclosed area.
Right.
And I think that the gist of what you're referring to is already established in 12 subsection 2, both in the A and B, and allowing for the establishment of the outdoor smoking area.
Right. That is what I was referring to.
Yes, I think
the outdoor designated smoking
that's right.
area.
So
which
I think that's taken into consideration to allow that freedom of choice if necessary in those situations.
Yeah, okay, fine. So we're specifically talking about enclosed smoking areas, which you're saying the third on concept could still apply there as a threat, but the outdoor, roofless type of environment would offer the opportunity for that kind of choice.
So also, Minister, you have to give consideration to the people who are responsible for cleaning up those areas.
Yeah, I get you. I get the third on.
Exposed to in an environment like that.
All right, I'm inclined to support that view, Mr. Edwards, and others. Then you have the Jamaica Psychological Society. Yes, that's what I'm proposing. There's the bill allows for dedicated smoking areas that are not enclosed. So you could have a section of a location where people can smoke, and it's.
So are we saying
but
that?
For enclosed areas, we're saying we shouldn't allow smoking within an enclosed environment.
Like a completely enclosed, like a smoking room.
Yes.
And I am sure that, the industries, the persons who engage, perhaps we can consider a requirement for air circulation, ventilation in those that are fully, because that's what the open roof allows, that there is free flow of air. So if it is entirely enclosed, perhaps we can have a requirement of a particular ventilation system that goes along with such to ensure that you remove.
Let me hear what Cheryl Dennis has to say.
Thank you, Chairman. So what I recall and what we are seeing from the draft is that it prohibits smoking in any area, or that the requirement in respect of the smoking area is that it must be structurally unconnected to any area where smoking is prohibited. Therefore, if we're even talking about the roof, it would also be prohibited there because of the structural connection. So what it does provide now is that it must be physically separated and structurally unconnected. Now, there's a scientific reason behind that also, because of the same vent issues. And I would want to say that certainly PAHO's position and the FCTC and its guidelines have very strong provisions in relation to that, which is treated with under Article 8 of the treaty, which speaks to not even allowing smoking rooms. So I'd want to say that what is currently provided for in the draft that we're looking at is supported by the FCTC and certainly by PAHO, because smoking in any room, all of that is not allowed because of the scientific evidence around it.
Mr. Chairman, don't we already have, I thought in Jamaica we had already banned smoking, even in smoking rooms. Don't we already have that?
Yes, the ministry has maintained that policy.
Right.
And I know there have been requests for smoking lounges at the airports, for example, which has not been granted. But we're dealing with the comprehensive legislation now, so it's a matter of...
And the 5 meters radius, 5 meters is what we're proposing for the distance from the building. Okay.
All right, so can we proceed then with the recommendation? And then we go to the Jamaica Psychological Society, radius and locations, which is addressing a similar thing. Radius of 5 meters does not provide adequate protection from secondhand smoke. I mean, the standard would be 5 meters, right, Mr. Edwards?
There's an inconsistency with that, Chair.
Okay, what's the inconsistency?
The concern is raised with the JP's suggestion, where in clause 12.3c, so in 12.1, the 5 meter minimum is recommended. But in clause 12.3c, it raises the point that smoke itself is not, it is a 10 meter recommendation. So there's an inconsistency of 5 meters quoted and 10 meters in the subsequent clause.
It speaks of 5 meters of the entrance, exit, window, or ventilation. And then the 10 meters would be...
10 meters, Chair, speaking
from
to
another
the
individual.
No, the 10 meters is speaking to the location of the facility,
Yeah,
not the distance from smoking.
The point is that the smoke itself is not going to know what distance it is. And at 10 meters, the fact is that, or 5 meters...
Well, the law is not for the smoke, it's for the people smoking.
Exactly, so we should be protecting against at the minimum exposure possibility, which would be 10 meters. So we are recommending that the minimum be 10 meters and not 5. And have a consistent distance across the board, because the fact is that whatever exposure you have, you will be at risk.
But isn't it speaking to two separate things? The 5 versus the 10? Mr. Edwards?
Yes, Chair. The 5 now in 12.1 is speaking to the separation of the smoke from particular parts of the structure. But 10 now is speaking to the actual smoking area, the distance of the smoking area from any other building.
Right. So why is there an inconsistency? Because the smoke is traveling across the distance.
It's not really an inconsistency, but you can make the argument if you want to standardize it at 10.
That's
say it's
the
an
argument that
inconsistency.
we're contended, because the exposure is there.
What is the sort of convention around that?
So so convention-wise, the greater the distance is fine. At the time, I can speak to at the time of the distance, which was when the regulations and the amendments were done. At the time, we were taking into consideration our own local realities in terms of where people could go, so as not to allow people to stand up in the middle of the road. However, from a convention perspective, the greater the distance, the better. So.
But I think our local circumstances can't be ignored. I mean, I'm not here in any way holding a brief for tobacco consumption, but if you take the little bars around the place and the street corners and so on, which is a characteristic feature of our society, you're right. You could actually be having a conversation with someone smoking who is in the middle of the road, trying to talk to you across on the bar stool, and I don't know if you may solve one problem and create an entirely different health hazard by doing that. So that's the concern I would have, member, although I appreciate the need to create the distance. Anybody wants to comment on that further? Any comments? No? You understand what I'm saying?
Chairman, I cannot recognize that against the risk that the exposure would be. And for me, put it this way, I'm very sensitive to cigarette smoke. If somebody is probably in the next room smoking, I will start to react. I used to be severely asthmatic as a child, and I can feel my throat tightening up. So it is, for me, the greatest distance, and if we are going to be going along with the policy of ensuring and enforcing public health, I think that the 10 meters should be the consistent.
You have twisted my arm. Mr. Edwards, should we adjust then?
No,
yes, go ahead, Senator.
I'm satisfied with the 5 feet because I still speak in, feet, see that? 5 meters, which is the equivalent of 16 feet. So you're saying a smoker should be 16 feet, which is about 1, 2, 3, 4, 5, 6, 7, 8 desks from here. And then the designated area would be twice that. I think how we are right now, how it is written, is reasonable for me.
So in that context, if an individual is standing within that closer range of that other remaining 16 feet, they're at an increased risk. So it is like, what is the difference between an individual standing outside of of a smoking area versus beside a smoker. What you're doing is making a distinction between the risk that the person, that individual is exposed to in secondhand smoke.
The designated area is where you're supposed to be.
No,
that's 30,
no, not
feet.
the innocent, the person who is not smoking. Let's say there's a restaurant that has the designated 5 or 10 meter, and that person has to go to the restroom which is near there.
They would be building the designated area in a way that would not
versus,
cause you to
versus
walk
a smoker
through.
who is standing outside or standing there and the person goes closer. The fact is that the smoke distance is still a risk. I think that there should be a consistency to protect against that distance.
Yeah, the challenge for me is just the practicality of it and the enforceability of it. That's a real challenge. I don't know if it makes sense passing laws that you can't.
I do understand, Chair, and I will yield, but I have to.
I know, I get the point, and I hate to be at cross purposes with you because I would love to see theoretically 20 meters, but I'm exaggerating. But the point is, how possible is that to enforce or to implement? And I think we would be setting ourselves up for the detractors to identify one aspect of the legislation to try and destroy the other very important parts of it. So I think we should go ahead with it as is, if I may say so respectfully, and proceed on that basis. Mr. Edwards?
Subject, Chair, to ensuring that ends are covered. We make the provision for ends to be included.
Yes.
Okay.
Yeah. All right. Now, it speaks also to enforcement and, business owners, non-compliance, robust mechanisms required to prevent business owners from, I don't know, I mean, is there insufficient specifics around the enforcement? The challenge with enforcement is that you put anything on paper if you do not have the oversight to really enforce, which has been a challenge, I must tell you, even with smoking in public spaces.
Mr. Chairman, what being consistent does is that it will restrict persons to the designated smoking area.
No, but how does that affect enforcement if people decide not to, or business owners decide not to abide by it?
It helps because you don't have to have 2 meters, 2 distances to consider.
I take the point about the enforcement. Is it that this is asking for a stronger fines, or what is it? I'm trying to appreciate what this recommendation is, because right now it's really a theoretical proposal without the specifics. Mr. Edwards, you can help me. Otherwise, we just move on, and I guess we will have to depend on the enforcement arm of the law to deal with these accountability issues.
And Chair, what we're speaking here is not monetary sanction. It's really the sanction of having your license or permit or whatever taken away from you.
That's monetary, as far as I'm concerned.
Well, it translates to, I agree, it translates to monetary.
Right. If you have your license suspended because you breach, I mean, that's bigger than paying a penalty, huh? The smoker in a public space can be cited for that breach, but the owner, I think, perhaps is the one who would need to enforce more. And if it's an issue of the license, it's a sufficient deterrent, I think. All right. Okay, Carriers Limited, they speak to 12.3C. Talking about distance, 5 meters across the Caribbean, and of course they are recommending a shorter distance. And given the intervention of Senator Longmore, I think we are quite okay with the balance because she was recommending a further distance. Then we have Jamaica Psychiatric Association looking at clause 12.1 and 3C, the basis of the 5. Okay, well, that has been explained. And, okay, so you've basically represented your fraternity well, Senator Longmore. And then you have Manufacturers Association, and it speaks the same distance issue. But I think we're pretty comfortable with that. So I think we should move on then to 13. Oops, hold on. Okay, no, I get mixed up. Okay, there it is. All right, so 13, we have the Jamaica Psychological Society, communication of smoke-free or no smoking area. And 13, by the way, is dealing with display of smoking signs. Okay. Definition for secondhand smoke. The Jamaica Psychological Society is asking for a clearer definition. Are members thinking that it's not sufficiently clear? Mr. Edwards? That's a standard definition, isn't it?
The team had agreed, the technical team had agreed that we would seek to strengthen that the second-hand smoking definition, or create a clear definition.
And you'll come back to us on that?
Yes.
Okay. And then the communication of smoke-free, this is 13 now.
Chairman, could I just seek clarification here? In that consideration for second-hand, are we going to consider third? Sorry to complicate the issue, but just perhaps we can explore that in your explorations.
We have to bring it up in the context of provision. So unless we're making specific provision in the law for third hand, we would need to define it.
Okay.
So we haven't used that term third hand. So.
Well, the issue of third hand came up from the NCDA in justifying the enclosed smoking spaces. So if we're going to use it on a scientific basis, and I think, I don't know if Ms. Dennis Wright had said it too, then we may need to, for clarity, add that to the definition. What do you think? Huh? It's not provided for in the provision. Okay. Is that something we should look at, though?
I think it is worth exploring, Chair, especially if we're trying to seeking to be consistent with international standards, because more and more the effect is being recognized. So at least seek to explore it.
What is that part of the literature, the international literature, Ms. Dennis, right?
So far, I have not come up on it in the definition because I guess because it is used in the normal or usual sense, but I don't see any difficulty in exploring it.
Let's leave it for now. I'm concerned about adding terminologies that can be challenged and then undermining the basis of the overall legislation. So let's go then to the 13 from the Jamaica Psychological Society. Recommendation of smoke-free or no smoking areas need to be made clear for individuals with varying literacy and developmental levels as well as differing physical abilities. I think that's kind of clear, and I agree with that. We live in a society when we must communicate to all forms of capacities and levels of abilities and so on. So, Mr. Edwards, you want to give some thought to that? Is there any objection, by the way, members of the committee? You don't need to say you agree over a lengthy period of expression. Just if you have an objection, though, I'll accommodate it. I don't want any clarity on the agreement. Just an objection, and I'll...
I thought it was clear. So I'm not sure if there was something specific the Psychological Association Society was referring to, because I thought throughout the entire discussion it was generally agreed.
Yeah.
Unless there was something specific.
Well, I would know from this, but I agree with what is being expressed. So, Mr. Edwards, we have to make sure that that is clear enough, so that if you have to put up a sign language, no smoking, or the letter written out, no smoking, or a patois language, no smoking, or dialect, local dialect, if you will, just for clarity and understanding, then I'm fine with that. All right, and then you go now. Yes. 13. No, the Psychological Society also has 13.3, list of places in the case of tourist establishments where no smoking signs may be placed. Not exhaustive enough, and it is suggested that it should broadly read potential publicly accessed places. Yeah. I mean, what are the thoughts on that? Potentially public access places. I've never heard that terminology. No, it's a potential publicly accessed places. How would you determine on that?
So, Chair, in the second schedule where it is listed, what the definition of public space is, what we're contending is that may not cover all spaces that the public might access. It doesn't. It does not. It does not. Take a look at the. Okay, no.
Second schedule, is it?
I think so.
Again, go ahead, Senator Allen.
I'm just asking, based on what was raised by the association, that it was insufficient. So I'm just trying to appreciate what was insufficient about it. I'm just trying to
understand. I get
understand.
you. And I'm kind of the same mind. I mean, I don't... Yeah, but again, we just have to be careful that we don't appear to be overreaching. If it's not necessary, because it's not a problem, don't make it a problem or a subject of a conversation or debate. I think we have to focus on what is the most critical.
Or Chair, if there was something, a specific place that was of concern, it
they just
could
put
be
a no
mentioned.
smoking sign.
If there was a specific
no
place, we
sign.
could just
So
include
you have the
it
fallback
instead of
just,
us trying to figure it out.
Yeah. So I would go with, if I may, I'd just keep it. I'd not accept this recommendation. Keep it as is. Yes, Ms. Dennis.
I wanted to mention as well that at the time of because this is a clause that has come from the regulations, and the regulations were promulgated, it was a lot broader in keeping with your suggestion. However, some consultations were subsequently held with the tourist industry, with that industry, and we had several consultations, and this was the safest compromise so as not to, impinge infringe. Thank you.
That is the point.
Rights.
So I'm as enthusiastic as you we all are, to see this go through in the protection of the greater good. But just, trying to ensure that we get it going. We have one other hurdle to cross, which is the Parliament. All right, so the 14, can I go to 14 then? And that would really suggest that we're making some progress finally. The pace. All right. Again, the Jamaica Psychological Society has a recommendation here. Part 6 of the bill, And this is no display of, no, not display, sorry, this is conformity with requirements. Speaks to Part 6, the Act should take into consideration the licensing of tobacconists, okay, individuals or businesses that are legally permitted to sell and distribute tobacco products, similar to the regulations and monitoring of individuals and businesses with alcohol permits. Developing a tobacconist, okay, license would support increased accountability and positively disrupt the act of selling tobacco products to minors, penalties, and so on. So basically, it requires you to have a permit to sell tobacco. I think that's the interpretation here. So as you would require a permit for a bar, a place that sells spirits, alcohol, you see those signs put up. It's saying that if you, it is my intention to apply for a spirits license. I'm getting the impression that this is suggesting that be applied as it relates to tobacco products. Am I correct? Is that what it is suggesting? I think so. I'm not so sure if that would be an anomaly from existing practice, wouldn't it be, Paho?
Thank you, Chair. While in theory we wouldn't be against it, it is not a part of the guidelines or the convention itself.
Yeah, I would pass on this for now and recommend that my colleagues do the same. That would effectively, if we are agreed, so we won't accept that, we would complete 14, so we'd then go to 15. And 15, okay, again, part 1, we start with the Psychological Society. Tobacco Control Bill and the Child Care and Protection Act need to reinforce each other in facilitating the protection of children in the purchase of tobacco products on behalf of the adults or even for themselves. I think the law is quite explicit, however, in the sale of tobacco products to children. So I'm not sure why this is a concern. Anyone wants to shed some light on that? I think it's quite explicit here that whether the child is purchasing for an adult or for themselves, that would be immaterial. The breach is committed by selling to a child. I think all of this is a lot now on the enforcement side. So I wouldn't detain ourselves too much with that. And then for 15, no, there's the Ministry of Education, Youth Information, and they have a few suggestions here. There needs to be a clearly defined section that deals with children and the related section on smoking and children. Is there a clear, there's a lot of clarity there, I would think. There should be a provision that makes it an offense for a parent or guardian to cause a child to have access to smoking apparatus. Well, responsibility of indirect and direct access should be prohibited. I would imagine that if a parent actively supports a child's consumption of tobacco, that would be an offense. Yes, deliberately.
But in this one, when earlier we were speaking about the electronic devices,
yes,
which can get confused in all other electronic devices, is that what the ministry is referring to here? There should be a provision made for the parent.
The challenge, yes.
I wonder if that's where they were going.
Maybe. The challenge here is that, as children sometimes do, the parent is very unaware that they are consuming a tobacco, whether electronic or otherwise, and is the parent going to be held liable for that? I'm sure all well-thinking parents would discourage and attempt to confiscate, if you will, those products once they discover it. Are we saying that they should be held liable? They are responsible. What's the thought around that, Mr. Edwards? Or
I'm just going to have a look at the Child Care and Protection Act, which I think is more appropriate for some of these matters, Chair. I'm just going to have a quick look.
You're going to do that now, or? Okay.
Continues.
You have quite a few things to report back to us on not tomorrow, maybe the next time we meet, because we'll give you a few days to. Reference should be made to detox clinics. These should be established at health centers where children can be referred for treatment, as well as hospitals for more severe matters where residential treatment is needed. And there's no protection in relation to the encounter with a child. And the police, where a child is caught with tobacco or marijuana, there should be provision for the officer to place the child before, is it what? Yeah. I mean, these are important issues. The question is whether we want to be dealing with these. Yeah. Yeah, that's what I'm thinking. So I think they are worthy of note and should be argued. The issue of detox clinics, the legislation does speak to that.
Cessation mechanism.
Yes, right. So, I mean, whether it is for children or adults, it is there. So I understand the emphasis on children, and, policy perhaps could guide that at the level of the institutions or the sector generally, but I'm not sure it is requiring of inclusion in the legislation. All right, so would that take care of 15? Mr. Edwards, will review,
Child Care and
right?
Protection
Yes,
Act.
yeah.
With respect to these comments.
All right, so we're going to go now to 17, and I don't see a 16. I don't see. There's no comments for 16. Sorry, so we're going to 17. All right. So part 1, query and recommendation. What does graphic health warnings actually entails, and is this applicable to consumers based on the varied motivation for using tobacco and tobacco-related products? This is from the Psychological Society. Graphic health warnings should be designed to include the varied motivations for using tobacco, tobacco-related products, and they're applicable to consumers. This must be just a comment. I don't think we can, we have graphic health warnings. I use it in my sectoral. We had former journalist John Hearn, I think. Is John Hearn? Right, so I appreciate the comment, but that's what, it reinforces the need for that. And then, is there anything else on 17? Where? All right, Chamber of Commerce, in respect of Clause 17.1 and Part 11 of the first schedule, the proposed increase of graphic health warnings from 60 to 80% is considered disproportionate and draconian, requirement will deprive legitimate companies of the use of their intellectual property rights, as there will be little or no room for product branding, an increase from 60 to 80. Okay, fine. So it's really saying we should move from 60 to 80. In some countries there's no branding at all. So we are actually allowing some wiggle room for branding, which I think is sufficient for now anyway.
This was, I'm sorry. I recall this being one of the clauses that we deliberated a lot on, and I don't recall what was the international standards in terms of the 60 versus 80 and if you could refresh me, please, Mr.
Sure.
Edwards.
Sure. Through you, Chair, to Senator Allen. So, yes, we had that discussion and noted that at least 114 countries require more than 50% of the package to be covered with these health warnings. Now, 71 countries have warning labels that are 60% or more. So specifically, you have countries like Nepal, 90% in terms of the pictorial warning size. India, Thailand, 85%. Australia, 82.5%. Sri Lanka, Uruguay, 80%. So you have Canada, the health warnings were increased from 50% to 75%. You know, so you have quite a number of countries where these health warnings are some even above 80%, and several, you know, in the 75, 80% range.
Thank you. But I just wanted to ask, and probably from PAHO as well, is there any material difference with 60% and 80%? That's just what I want to understand. Do you have any data to say that the ones that are 75% or 80% are more effective? And then the other question I just want to raise, the concern as it pertains to our own laws as it relates to branding and content. So the chair just mentioned that some packaging are totally blanked. I know that our Bureau of Standards requires certain markings and ingredients, etc., to be marked in terms of the labeling. So that's another concern. So, Mr. Stein.
Thank you. I can say that I don't have it at hand, but I know that there is data that actually speaks to this particular matter. And it's for this reason the number of countries, which our colleague has mentioned, has moved from increasing from, as an example, from 50 to 75 to 80 based on that research. And so the intent is to limit the branding issue. Branding is largely an intent to gather new clients or consumers, I should say. And so the research does show that there is an impact in increasing the public health warnings and limiting the branding side of things. Thank you.
If I may, as a trained marketing practitioner, I can confirm what has been said. Branding is perhaps more valuable than the product itself and its impact. It is. I mean, when you consider the sale of a company, it's the reputational value around the brand that commands the price. Sometimes not necessarily the product that is contained in the packaging. So it does have an impact. And as was said earlier, globally, this is a trend. So I would leave it as is. And I think we are doing the right thing in this case.
Yeah, so Chair, I'm not contemplating the branding at all. You know, we know that branding is quite significant, but it's a graphic health warning. That's why I refer to Mr. Steins, because the branding, however we take it, even if we reduce it to 10%, there's still going to be a 10% branding there. So it's not the branding that I'm particularly referring to. I'm just referring to the graphic health warning as it is outlaid here. So. And I agree with Chair that branding is critically important. But I just wanted to know if there was the material difference. And you said there is. I'm sorry you don't have that data at hand to say if we start going 80% on our graphic health warning, that we'll see a 5% reduction or 10% reduction, whatever the case may be. But it's something that we would want to, and I'm pretty sure the rest of the colleagues would want to have that information as well.
Yeah, no, that's fine. I think that's...
Just supporting the argument that for those countries, especially those who would have moved from a particular percentage of the graphic health warning to a higher percentage, what would be the reduction in sales, if any, for that? That kind of data would be helpful for us to understand the need to go there, especially against the background where we are now, the Chamber of Commerce is saying it's too draconian. And then the other side of that argument would be for us to demonstrate the benefit by doing so, with illustrating the reduction in sales. Reduction in terms of yes, and all of that.
I think when that time comes, we can make...
But not for today, Chair. Not for today, but it will be helpful information.
Right, I appreciate that. When that, yes, you were saying something?
If I may, this whole issue of the health warnings is implementing Article 11, which requires the parties to ensure that tobacco product packaging and label carries large, clear, visible, and legible rotating health warnings. Now, these the guidelines in relation to this article have noted the evidence that warnings with both pictures and text are more effective than those with text only. And this is why provision is made that parties should consider pictorial health warnings on all the principal display areas of the packaging.
And I think that that is impatient of debate, to be totally frank. So I really don't think we should detain ourselves too much on this.
Okay.
Senator?
Yes, thank you. Just one quick point, though, Chair, in terms of Senator Gill's suggestion. The fact that we may not definitely see the behavior change that you anticipate from this is especially in the initiation of smoking. Is the new smokers who this might be most effective in. So it might not be reflected in the tobacco sales itself because the chronicity is the right. So it's the start in behavior that this especially stems.
And again, not to appear, but advertising serves two functions. It informs and it persuades. And I think we owe it to our consumers, or unsuspecting consumers, to inform them about the consequences of smoking, particularly the first-time ones, and then hopefully the graphic details will help to persuade them not to, or those who are, to stop. So I think it's a very important tool. Sorry? I'd like to. I hope we will be back here at some point discussing front of package labeling, but that's another issue. Or trans fats for that matter. All right. So let's move on. So we'll keep that one. So 18. Can we go to 18? Okay. We're doing nicely, I think. We have another 40 minutes. Prohibition of public and public and self-serve displays. All right, so we have the carriers group, and they're saying that it is proposed that clause 18.2 be deleted, and reference to electronic delivery system should be eliminated since it is not a tobacco product. Clause 18.2, let me see what that is. No person shall display a tobacco product or relevant product in such a manner as to cause it to be visible to the public. So they want that display, that eliminated. Mr. Edwards, how consistent is that clause with other legislation or other commitments we have made? I mean, in other words, a store that has a sign that says tobacco sold here or cigarettes sold here, would that be a breach as is being proposed now?
Chair, this is a little different because this speaks to displaying a tobacco product or relevant product. So if you're selling it in a store, it mustn't be obvious to someone who walks in to see it. I think I've seen it in the Trinidad legislation. Mm-hmm. There's similar provisions. I'm not sure, but I've seen it in other provisions in other jurisdictions.
Okay. Any other? Yes, Ms. Dennis, right?
Yes, Minister. In relation to the specific example that you gave regarding the signage indicating where the tobacco product is sold, that also falls under Article 13, which prohibits the advertising of the product, and therefore even something like that would be prohibited.
So I know that we are prohibiting advertising of tobacco products. The question is it strictly considered advertising? Okay.
It is, Minister.
It is, okay. So that would be a no-no then. And then the issue of electronic tobacco or electronic delivery system, I can flatly reject that because all the evidence suggests very, very otherwise. And indeed, it's so controversial that even in the United States and other jurisdictions, they are banning some of these products. Jamaica Chamber of Commerce, Clause 18.2 prohibits the display of tobacco. Okay, same thing. So we'll just assume the same response. Jamaica Manufacturers Association, ban on the display of tobacco products. Industry believes that the clause is disproportionate, prohibits the display of tobacco products for sale. The effect of this clause is to treat the product as an illegal product. It is recommended that cigarettes are sold from behind the counter in outlets, so it does not allow for self-service or to be stored and sold for designated. All right, so this is pretty much addressing the same issue in another way. But tobacco clearly is allowed to be displayed, meaning if it's behind the counter, it's in a gadget that you take on the shelf, which in and of itself is a display, right? And that's not prohibited in the current legislation. So it's really just allowing, in a sense, it's storage where they store it, but they store it in a visible place. Is that what it is? Huh?
What they're saying to be sold from, so it's really storage to be sold from
yeah, Mr. Edwards.
Under the counter.
Mr. Edwards, what, I mean...
Well, the prohibition is really on displaying publicly. Sorry, the prohibition is really on displaying the product in a manner that it can be seen by the public. That's what 18.2 is providing.
So that would mean that there is no display of the cigarette product at all.
That's
so
right.
She would be correct. It's not just behind, but under the counter.
So this is, say it again, Mr. Edwards, you're saying that this is the display to say you sell it,
that's
but,
right.
but not it.
Huh? Sorry?
But not the product. Not the display of the product.
The display of the product is what is, in a manner that can be seen by the public, is what is being prohibited.
Okay.
But,
but not the display to say, I sell the product.
So the casing, essentially.
Yeah, I'm just wondering, because, I mean, you go into a convenience store,
yes,
you know, a 7-Eleven in Miami or whatever. You see the tobacco behind the counter, behind the cashier, on the wall, and it's there. And in a sense, it is being stored there, but in a sense, it also represents a display. So people know that it's there. You don't, so are we saying that that would also be prohibited? And would that be draconian, or would that be viewed as excessive?
Sorry, also, Chair, consider the sign that says cigarettes sold here.
No, that's a different thing, right? I'm talking about the actual physical product, and it being lodged somewhere where persons can ask for it to be sold. I mean, would that be considered as being excessive?
So you're not going into the supermarket where you can see aisle 9 and it has cigarette, right, or aisle 10. So it is in there. It's in a convenience store, but there is no label to attract you. You have to ask feet if you want it.
But I think Senator Gale has hit the nail on the head when he speaks about convenience store. The whole idea is that it should not be so displayed in a manner that is so convenient that even if you weren't thinking about it, you say, oh, you know.
Yes, let me hear what the NCDA has to say.
I think generally they're displayed in a clear case behind the cashier.
Yeah.
So it's branding, displaying, it's visible. And as it say, it would evoke the thoughts of, okay, I forgot, or I need to get my cigarettes now. But usually it's in a clear case. So are we saying no to that? Because then they would have to now devise another mechanism to distribute their
I think
cigarettes.
the issue becomes whether it is classified as storage or as advertisement, because it has to be stored somewhere. And if someone decides that they want to store it in an elevated section of a location where it is viewed as many do, I mean, can that be seen as advertisement? Yes, Mr. Stein.
Thank you, Chair. I think it's important for us to recognize that this is tied to the previous conversation about the graphic display and branding. So when you have packages that still have branding, the display of them is a form of advertisement. So let's recognize the fact that these are connected. The intention here is, of course, to limit the display, because by displaying them and still having the branding there, it's a form of advertisement. And we know that the research does show that by limiting this display and limiting the advertisement, that does have a direct effect on consumption and uptake. And I would also go further that globally, 80 countries have enacted point-of-sale tobacco product display. There's many countries that have gone this way. I can speak from my personal example in Canada. It has actually a closed device, right? It's almost like a closet that you have behind the counter that persons who would like to purchase tobacco products, they would say, I'd like to have X product. The person selling the product opens the cabinet, which is opaque, and retrieves the product and sells it to the person. So it's intended not to be a glass piece. It's intended to limit the display.
Where else is that requirement? Okay, it's certainly not in the U.S. or
I think in Australia and Canada are two examples that I'm familiar with.
So in Canada, there's no public display at all of tobacco products.
And in Panama.
Chair, when Mr. Stannis.
Let me hear Mr. Dennis and then I'll come to you. Go ahead.
I was adding, my apologies, I was also adding in Panama. Yes, and we do have some statistics. So earlier, there was a request to read statistics. We have some statistics in relation to this particular provision, which shows that where there is a complete ban, then the reduction, especially among youth, there is an evident reduction.
Well, there is such a thing as impulse shopping, again, a marketing term. And one of the reasons why these products are at the cash counter is because people, if they don't normally go in to look for them, but they do take them on their way out. That's the chocolates and the sweet, the little confectionery stuff. And it works, the psychology of that space. So I don't think the science of it, social sciences of it, is proven.
But isn't that why, Minister, if I might interject, that you would have the 80% graphic warning? You know, because the graphic warning, whilst it is communicating the message that to discourage smoking, if you were to choose and go with your impulse, in the case that is behind the counter, out of your reach to act upon immediately, the graphic warning is a deterrent. And so that is why you have the graphic warning, to counter the impulse decision making.
It doesn't.
I'm not going to delve too much in the science,
sorry.
This particular clause is one of the strongest deterrent. It is not available. You only know about it because you know it's there. And even if you're going there, you're not seeing it, you have to ask for it. So that person who wants to try the cigarette in the first instance don't know where to find it. It is the constant smokers now who would have gone there before and is aware that they can go to Mr. Edwards and say, Mr. Edwards, give me a pack of Craveney. And Mr. Edwards would have it and know where it's, but it's not shown anywhere. And so this particular clause is a strong deterrent.
Chair?
I like your energy, Senator Gale. Yes. Oh, Mr. Edwards, yes.
Yeah, Chair. So you were asking about other examples. So in the UK, since about 10 years now, it's been prohibited to display products, tobacco products in shops, in large shops, except for, I think Mr. Stein was indicating, incidental display, if a staff member is moving a product around the store, or if somebody makes a request specifically, somebody over the age of 18 makes a request. So in other words, these products will be treated just similarly to how you treat prescription medication. You know what you're going for, you ask specifically for it, but it's not displayed.
Okay. I think that is sufficient. Well,
Yeah, just to add, Chairman, that the crux of this is the power of choice. And the point is that if an individual is even contemplating to give up smoking, just the mere sight of it could cause them to purchase. And it makes a big difference in that respect. And if the tobacco industry is concerned about their sales, the person is so addicted that an addict will know where to source their tobacco.
I think we're agreed. So let's hold then and not accept the recommendation. Boot to go, 18.2, risk associated with strong tobacco products under the counter. Okay, so the same issue, but I think we're agreed. So we'll move on to 19. Okay, so 19, we have an observation from the WHO, inconsistency or typo regarding the size of the area of the graphic health warning percent, okay, between section 23, 60%, and first schedule, part 11B. Oh, sorry, 19, sorry, I'm at 20. This Jamaica Psychological Society, penalties for non-compliance should not rely only on fines, but be more demonstrative, such as community service, orders focus on the drug misuse, persons who find themselves in conflict with the law to understand the long-term effect of their actions. More psychosocial approach to behavioral change should be attached to punishment and not just finance. Again, I hear the observation, but I don't know if we can situate that into the legislation. Yeah, I probably would not. And then Carreras, 19, the definition of public place is very broad, and as a result, this provision stands to impact thousands of businesses. Ban on the sale of tobacco in public places should be removed from the bill as it stands to severely affect small businesses. Okay. Additional regulation that the minister would like to introduce should be evaluated based on all the interested parties, including the Parliament that approved the Tobacco Act regulation. Propose that clause 19(1), C and F be eliminated or the law or amended, such as, for example, the law in Trinidad and Tobago, I guess, mentioned in clause 4. Comments on that? Clause 19(1). No person shall sell or offer for sale a tobacco product or whatever. Yeah, no, I would hold on it. I mean, any comments here? Any comments?
Just, I'm not clear on what the reference is to Trinidad, I would suppose, TNT. I wouldn't know what the difference would be with what we have here and what's there in Trinidad. It wasn't mentioned. So unless we're going to get some additional information as to what holds in Trinidad, then I would say leave it as be.
The clause 4, powers of the minister. Although the bill establishes a complete ban on the advertisement, promotion, and sponsorship of tobacco products, clause 4(1)(f) contains a clause that may be misinterpreted. It is suggested that consideration be given to removing the words "or advertising." Is that it? Oh.
They made mention of the Trinidad and Tobago regulations.
Oh, right. So in clause 4, they had mentioned the Trinidad and Tobago. They said the minister may make regulations subject to affirmative or resolution of Parliament, prescribing requirements and standards for tobacco products constituents, including emissions of smoke products. In other words, it's empowering the minister as opposed to specifically providing a statement. But I would keep it as is in the bill, in the legislation. The Jamaica Chamber of Commerce speaks to Clause 18.2 prohibits the display of tobacco products, which was, okay, I think it's the same thing, right? Hold on. We're not 19.
Mr. Chair?
Yeah, 19. Yeah, public spaces, right?
Yes, Mr. Chair, I wanted to ask a question about the public places being cited specifically. Mr. Edwards, maybe you could help out with that. Why is it singled out there?
Yeah, thank you for that.
And how do we define that?
Yes, well, it is a defined expression, but the truth is that this is something that the technical team recognized that there needed to be some refinement because it was too broad. It is too broad, as it is currently stated. And the team, therefore, would seek to indicate that the intention really was not to cover every place accessible to the public, but defined categories of places, you know. So it's not intended to cover anywhere that's accessible to the public, but it is.
So essentially, C should be removed. That's what you're saying?
No, the definition of public place would be redefined. Redefined, because it's a defined expression.
So, okay, all right.
Yes, you have to define public space, because if you're saying in B that you can't sell, that vendor that sells some juice and might sell some cigarette can't sell outside of the National Stadium. But if that vendor moves any further, they are still in the public place or the public space. And so what you're doing is you're removing it off the shelf in what would be in 18. And in further 19, you're saying that it can't be sold anywhere in the public space, which is everywhere. Even if the man walks on the street and is not static, but is walking with the cigarettes among some other items, they still can't sell it, because they would be in contravention now of what is constituted in 19.2, committing an offense. So we really need to be clear on what the scope of 19 is suggesting, in 19C specifically, and how 19C reads with 19.2.
Or might I add to that, Senator Gale? So the concern raised by both Careers and Jamaica Chamber of Commerce is consistent with what it will be resolved by the definition of public spaces, what that means, right? Correct?
Yes, we would expect that, yes.
And then there is the matter raised by Careers for F, which is any or such other places that may be prescribed by the minister. And so that's left as is what we're saying.
You get back to us on that definition, Mr. Edwards, your team.
Yes, Chair, but is there any other thinking of the committee members in relation to this public space issue?
I think the consistency has to be achieved between the clause prior, which speaks to the product being available but not displayed / promoted, and the attempt at selling within a public space and achieving that similar objective. But I can understand the conflict that could result, because if you have, I'm contextualizing for Jamaica now, dance, probably, party, and a vendor decides to sell peanuts and cigarettes and starts walk through the crowd and selling. That's clearly a public space. I mean, is it that he would not be allowed to do that? And the enforcement of that. Although the truth is, the smoker, the demand side, that's the supply side, the demand side really should not be allowed to smoke in that space, because they'll be exposing others to secondhand, unless they get the 5 meter, which is probably practically not possible. You know, the dilemma with all of this is really the kind of balancing the desired effect with the practical implications of how the society works. That is not a justification for allowing it to happen, because I do believe we must use laws to steer behavior, and in this instance, health-seeking behavior. So I'm not saying we shouldn't do it, but that's the real issue. The other one that I think we're going to have to address is secondhand smoking from herbs, from marijuana, because I think that we have more of a challenge with marijuana smoking in public spaces than cigarettes.
Let me tell you about
and we have really confronted that, but I know that is
for another day.
That's for another day.
Minister, might I ask a question? Huh? Might I ask a question, Minister, of you or Mr. Edwards? When I look at 19 again, 19A, B, D, and E, I can't see what else could be considered public space. I'm just trying to get at the question, do we define public space or remove C? Because everything else, healthcare facilities, sports, athletic or similar facilities, educational facilities, childcare facilities, I'm trying to appreciate what else could be considered.
It could be funeral, it could be a burial ground.
But isn't that where the 5 meter would come in then? Huh? Isn't that where the 5 meter distancing would come in? That was in...
Well, that could be contained in the definition.
12?
That could be a part of the definition. But I think public spaces could be several other places.
Chair,
it's really where people congregate and where people interact within a proximity of each other, that one action could impact another. And it could be a formal or an informal setting, something like that, I think. Huh?
So, Chair, this goes back to what we had suggested in terms of the potentially public space, which we had moved away from. But the thinking behind it was that these spaces could emerge and they are not covered by the legislation.
Which is why the definition of public space is important, I think.
Exactly, and that's so why we had made that suggestion.
We need to put ourselves in that. Now, my view on it, Mr. Edwards, is that it should really represent any space where there is a body of individuals that may be the public, right, where they may be there for a similar occasion or otherwise, and where tobacco consumption can have either a direct impact or an indirect impact, not necessarily through secondhand smoking, but through the influence around exposure and so on, right? That kind of jargon, I think. I'll allow you to deal with the legal side of it.
Sure.
Okay.
Currently, we define it in the context of places available to be used collectively by the public, including government offices.
Yeah, for sure. All right.
And Chair, we note that this generated a lot of discussion and a lot of communication from the members of the public on this provision. Thank you.
So Chair, just for my clarity, so is the suggestion then that we remove the word public place and we make a list of
No. If you do that, you'd be asking for trouble, because if you miss one, it becomes a problem. You have to define it. You have to define it, and I know the definition may be subject to some interpretation. That may be the limitation. That may be the limitation on it, but you have to define it to capture as wide as possible.
Because somebody
go ahead. Sorry, finish your point.
So I was just saying, it depends. Then it will be dependent on who is. It's kind of a bit fluid, because then someone will say, this is a public space, while others will consider it's not. And so I'm seeing a little gray area there, which can pose a significant problem, and that's why I am trying to get a clarity as to what is being proposed, albeit that we don't want to make a listing.
Right. Ms. Dennis, right?
Yes, my concern is similar to what was expressed just now by the member. I was of the view, and I'm just asking for clarification here, I was of the view that all that was needed to remedy the concern was to delete the reference to public place in C here. I remember also that maybe in a prior or more than one sittings prior, that was what was suggested, that it would be remedied by removing public places. I'm not sure maybe where I fell off in terms of following up read the amendment to public places, because what I recall is that this is the single most important definition throughout the Act, and therefore you will have to look at how it is used in almost every single reference if you are to amend that definition. So although I'm seeking clarity, I'm also making a suggestion that if the current definition works, that it be retained, because as it is in keeping with the with Article 8 of the Convention, and that the concern regarding public place here be removed, if that remedies.
I just wanted to say, Chair, that the way I'm interpreting it, and I'm not a legal mind, is that it's anywhere that's not private. So I'm thinking that, I know Mr. C, that's why I need clarity, because now I'm thinking that once it's not your personal space, then you can't have any form of sale interaction with tobacco. And then to the example that the chair brought up is very key. Coming from the rural areas, we have a lot of sessions, we call them dance. And you'll see the guys walk around with the cigarettes and other stuff for sale, which is also a form of advertisement. Now, when that person is going around, they would be, based on what we're discussing, they'll be in breach, because they'll be clearly advertising cigarette, because the branding is there. You'll see the packs, and that's also another consideration in terms of enforceability that I just want to bring up. Thank you.
Here, when you look at the definition of public place, it means any structure, facility, place of assembly, or D, other place. You're not escaping, only if you go heaven.
Even heaven. And you won't be there, right, Cameron?
I am going there. I hope to go there. But what D is inclusive is saying is that you're not escaping. Anywhere you go, you can't hide or stay in your yard and smoke.
Right, correct.
So we really have to consider the inclusion of public space.
You mean the definition?
The definition.
So. We're all agreed on that. Yeah. Yes.
Chair, I just want two points to convey. The consideration of where the public may gather, I think that might narrow it a bit. Don't know. Instead of public space, say where the public might gather. And then Senator Golden, who is absent at this time, she indicated a question: does public space include a private facility that invites the public to attend? So if she has a party at a restaurant that is open to anyone to attend, would that be included? But that's what I indicated to her that it would. But in terms of the removal, I am suggesting perhaps we consider where the public may gather, because that now puts it on the gathering of persons rather than the space.
What Senator Longmore has brought up highlights the fact that this provision, a lot of emphasis has been placed on the public place element, but this provision is dealing with the control of sale in certain places, including certain public places. So it is covering a whole range of places and not just public places. Public places is one category of the places. A lot of these places may be private. So this is why we have to carefully define what the public places are.
I think we have ventilated the issue sufficient to give a mandate to yourself, Mr. Edwards, and the team to come up with a definition to capture what we're trying to get at. The key is in what we're trying to achieve. And we're trying to achieve non-promotion of and contamination of smoking. I think those are the key issues. So just defining the terms in those terms as it relates to where people congregate and how they use and what can be used. I smell the lunchroom. I'm almost tempted to go downstairs.
I wonder where you're right. Minister, I hate to
you,
belabor this so much so. But now that you've just clarified that, and you have, and Mr. Edwards too, based on the fact that you're saying that no person, this is about the sale, right, Mr. Edwards? And if the sale in this instance, in addition to all these facilities and places, says public places, and then public places is defined as basically everywhere, you're saying that you can't sell anywhere in Jamaica.
This is why we're focusing on the redefinition of public place.
Why not just remove public places from here?
Well, that's a matter of
sale.
Well, that's a matter of policy. What we would then be doing is reducing the restrictions in relation to sale.
Okay, got you.
Let's await the proposed definition and then we make a decision from there. Because I'd be hesitant to remove it because I think it allows too many gaps, and that could be argued. But let's await that. Okay? Can we try and do a couple more before the 12:30 cutoff? And yes, I do smell something, but it has a little aroma to it. It doesn't smell like... Really? No, it's not cigarette. I can tell you that for a fact. This is the parliament. We would be committing significant breach there. All right, hold on. Let me see where we are with item... I think we're finished with 19. Part 2, okay. Part 2, 19, we have the Ministry of Education, which speaks to being suggested, similar to the regulation of marijuana, where persons are not allowed to cultivate marijuana within 188 meters of certain areas to ensure that persons within these public places are protected. A similar distance should explicitly be stated in the bill. Section 19.2, where a person body is found guilty of continuous intentional or negligent exposure of children to this risk, maximum sanction be recommended as the penalty. Okay, so what do we say about this? I mean, do they, well, yes, they do actually. They cultivate tobacco in Jamaica, right? People grow tobacco in Jamaica, yeah.
I think I'm in agreement that if it is a continuous intentional exposure of the child, I think there should be the...
But isn't that kind of...
that might be covered elsewhere.
Maybe I should ask SG, is it a sort of... Is it implicit in the law that repeat offenders may have to be... are meted out with stiffer penalties? It's not...
Perhaps in the Child Care and Protection Act, something relates to it.
All right, so there's a mechanism that is put in some laws where it says on a first offense, the penalty is such and such, and on a second and subsequent offense, they then give you a higher penalty. But generally, most penalties are maximum offenses. So the judge will take into account a number of things when sentencing the person. So on a regular basis, the person won't necessarily get the maximum. But if the person is now a repeat offender, then the judge could be inclined to give them a harsher penalty. But it wouldn't exceed what the maximum is, which is why for some offenses, they have decided that that maximum should not apply to someone who is a repeat offender, which is why you may have the mechanism where you say your first offense is lower and a second and subsequent offense is higher.
Right. So the question is whether or not we should, in accordance with this recommendation, go with a kind of tiered recommendation around repeat offenders, or allow it to the system to determine on that.
Chairman, through you, is there a special consideration for children in terms of repeat offense against children?
Okay, so sentencing for children would be dealt with a little differently. And generally, they are supposed to go before the children's court. So for children, you're not going to, whereas for adults, you may be looking at, say, a custodial sentence and so on. For children, they're going to look at alternative methods.
No, not the child being the perpetrator in terms of the exposure, negligent exposure. So the offender is repeatedly exposing the child. And the recommendation is that they get maximum penalty upon such. So what you just described was that it usually obtains that there is almost a tiered approach. But what the recommendation is saying is that once it has a repeat offense for children, it ensures the maximum penalty.
So if that is what the committee would want, you would need to then put that in the law. So we have in other legislation where we will have harsher penalties if the victim is a child. And that is suggesting to me that. But then you would want to then make sure that you have consistency. So I would suggest if you're going to do something like that, you shouldn't just look at one offense. You should look at whether you want to do that throughout the bill. So that anytime a child is a victim for any of the offenses, then you would say you add on an additional, whatever it is for the fine, or additional 6 months for the custodial sentence. So I just think for equity and so on, I don't think it would be appropriate that you just do it for one offense, or at least you should consider whether it's appropriate for all the offenses or some other offenses.
Right. Yeah.
But Chair, wouldn't the judge at his or her discretion?
Well, that's what I was saying initially, that the judge probably would exercise discretion around the nature of the offense, and having been cited for a breach once and then committing a similar breach twice, then the judge would likely take that into consideration. But we could be more explicit, which is where the law is going now in terms of gun crimes and so on. I mean, this is not comparable, but I don't know.
And Chair, there could be mitigating circumstances. And I'm generally on the other side, by the way, but there could be mitigating circumstances in some of these.
Well, the reason why,
I'm just thinking that, we may not be fully grasping all the different situations or events that may occur leading up to an infraction. So, in my mind, I understand what the tertiary student council is heading at, but if we leave it up to the judges, we must have confidence in our, judiciary.
I agree, but the challenge I have is the children part of it, because I really am concerned, to be totally frank, that the breach as it relates to the impact and the negative consequences on children is one that deserves some sort of special attention. Particularly when it comes to things like the e-cigarettes, which are becoming a huge problem in the schools. They are attracted to this, and the same culprits tend to pop up at different institutions committing the same infraction by supplying these devices. I've seen evidence of that, and that's something that concerns me. So, Mr. Edwards, I wonder if we could look at that possibility, given that this is more around children, as opposed to the general population. Anyone who commits that, any repeat offender around supplying children or education institution is a deliberate act that is committed, premeditated, and committed to targeting that cohort, which is our most vulnerable cohort. And I do believe there's an argument to be made for dissuading, discouraging, or penalizing even more consequentially that kind of deliberateness. And I think that has been the general impression of in particular the e-cigarettes and our schools. The same people drive around and supply these kids with these things, and it bothers me personally, I must say. Yes.
So I was going to say there is a sort of precedent in what we just call the anti-gang law. In that law, if you recruit a child to become a part of a gang, and you do that recruitment within, I can't remember if it's 50 yards or a certain distance from an educational institution, the penalty is harsher.
I like that. So, I mean, besides what, I would like us to look at that, if with the consent of our committee members, of course, that we provide some sort of stricter penalty for targeting children and repeat offenders in this regard. I think there's a case to be made for that. We can look at that and come back to us.
Just asking again, and perhaps if the Child Care and Protection Act has something that provides for this with the repeat exposure. So perhaps we can coordinate the legislations.
It doesn't.
It doesn't.
Not specifically, no.
It doesn't?
No,
okay,
it doesn't.
then I am definitely for it being recognized and included.
Chair, my last question is to Paho. I'd like to pick Mr. Stein's brain. So I just want to know in other jurisdictions how this particular issue is dealt with. If you can just share your experience. Thank you.
I'm actually going to defer here because I actually am not familiar with this particular issue. If I may, please.
Okay, and this is in relation to children, yes? Pardon? Repeat offense. Right. Right. So in examining other jurisdictions and other pieces of legislation, I do not recall seeing anything specific, repeat offense. But as it relates to children in general, there are always strict provisions and penalties as it relates to safeguarding. In fact, as you know, this particular provision that we just looked at is really, the backbone of it is really in relation to youth exposure. So where there is any kind of exposure, whether it is recruiting or otherwise, there is always a lot of focus placed on that and in urging countries to put in place strong penalties and provisions to safeguard children and to protect children in general.
So would you say if these infractions are carried out around a school, a sports complex, there would be a tier system where it's more where there will be harsher penalties?
Certainly, certainly, and that's why I'm saying even in relation to the provision that we just looked at regarding the prohibiting just even sale around schools, educational institutions, stadium, things like that. So as it relates to general recruitment or the protection of children, countries and certainly those who are parties to the convention are urged to put in place strong provisions.
Okay. Yes, Senator. Sorry, I was a little distracted.
Mr. Chair, sorry to really belabor the point, but I note the recommendation, the first recommendation from JUTS, and I wanted to pose it to the technical team just to see if that's of any moment or if there are any other instances of something like that being included in other legislation. So looking at the cultivation of tobacco, in spaces where children would be likely to be exposed. I wondered if, we thought that the bill should go to that extent.
That's not included, no, is it?
No, it's a recommendation here from.
Right.
From
so
Justice.
I am inclined to support the kind of non-consideration, if you will, or not accepting that recommendation, because that could be fraught with all sorts of issues, which again becomes an enforcement issue. So I don't, it may be just a moot point, but I don't know that there are any laws that support that.
Yeah, that's going into a different area, Chair, because that is going into regulating the tobacco industry. That's a different action from regulating, tobacco control. Is this different?
All right, so I think we are agreed on the rethink or relook of what we've said about children and the targeting of children. Can we just try and finish up? We're 3 minutes. Well, we only have one more, right? One more, which is, hold on. Jamaica Manufacturers Association, right. So let's try and finish up 19. So the recommendation here is product sales in public places. Government is being urged to rethink and amend provision. Okay, so it's the same, based on these restrictions, will be forced to discontinue selling in tobacco category, robbing them of. All right, so this is the economic argument around the sale of these products, but I don't know if this argument holds because it's not stopping bars and restaurants from selling. It's just the display component that is a problem. So I think this, yeah. So I think we'll stick to the definition as said, which should hopefully bring some clarity to the position here. And if we're all agreed on that, that would take us to the end of Clause 19, and we will suspend. I think this is a good time to suspend since we have a 12:30 deadline, and we pick up again on Clause 20 tomorrow, right? And just to remind you that tomorrow is a 9 o'clock start, 9 a.m. that is. And we need at least 4 members, including myself, to constitute.
Let the record show the person who traveled the furthest.
Yes,
was
and
the
we
first.
want to commend Senator Allen, who traveled all the way, who flew all the way from Montego Bay. Almost. Please be careful on the roads. And who was here early. But just to remind members that we are prepared to accept that it may have been an oversight today, given that we normally start at 10. Are there any other business for the day? No? All right, so I want to just set the date for the next meeting, which is tomorrow, 9 a.m., and we go up until 12:30. I think at this pace we should be able to make some additional progress, so I'm very pleased with what we have done today. I want to take the opportunity to thank all who are here, of course, members of the committee, the parliamentary staff, the support technical team from the ministry, the Solicitor General's office, the Pan American Health, of course, my office, and I think combined we have been able to clarify some issues. Mr. Edwards, there are a couple of things that I know your team and yourself will work on. We will not require a response to those things tomorrow, so we just continue because we will break. Now, I am going to be away for 12 days, or is it 14? Commonwealth meetings in the UK and then WHO in Switzerland. So I'll be back on the 28th. Is it possible to appoint a deputy to continue these meetings, or should we wait until I return? I don't. Yes. So we'll be out. So no meetings can be convened if I'm going. What? I'm told that the May calendar is booked, so we may have to wait then. Sorry to hold you up. So what will happen is that we'll try to do a few long sessions when I'm back to try and bring some closure to this. All right? Yeah, so maybe we need to look at the June calendar to see if we can get 2 additional days like today and tomorrow, and then see how far we can advance. So members, if there is no other item to raise, thank you again. Appreciate the time, the effort, the thoughts, and we look forward to seeing you in the morning at 9. Meeting is adjourned.